Diana Shepard. I'm the editorial director of Divorce Magazine and a facilitator here at the Divorce School. Today, my guest is family law attorney Ginger L. Dugan, who'll be answering some of the most frequently asked questions about the divorce process in Florida. Ginger practices in all areas of family law, including divorce, spousal and child support, asset and debt division, retirement and pension division, parental responsibility, and child custody. She also practices wills and trusts, probate, and bankruptcy law. Welcome, Ginger.
Thank you.
Ginger, let's dive right in. What are the grounds for divorce in Florida?
In Florida, the most important ground to remember is that Florida has no-fault divorce. So as long as the marriage is irretrievably broken, then the parties can be divorced. The other ground that is less likely to be used is mental incapacity of one of the parties. If someone has been mentally incapacitated for at least 3 years, then you can also get divorced under that ground, but usually people just do the irretrievably broken, no-fault divorce.
Is there any advantage to using the mental incapacity ground over the no-fault, irretrievably broken ground?
The only reason why you would ever use the mental incapacity ground is if the other person was mentally incapacitated and you no longer wanted to be married to them. The typical case that comes up in Florida is the Terry Schiavo situation. We most of us have heard of that, and if not, Google it. It's a definitely interesting and heartbreaking story. But if your spouse is unable to function mentally, and you wouldn't be able to just divorce them under regular law because you would have to have the capacity to, for the other person to be a part of the litigation. So it's just a way for you to actually get divorced if that person does not have that mental capacity.
If one spouse doesn't want the divorce, can she or he stop it?
They can stop it for a time. If one spouse thinks that the marriage can be saved, they can ask the court to order marital counseling, and the proceeding can be kind of put on pause for a certain amount of time, but it's not inevitable. If one person thinks that the marriage is irretrievably broken and wants to be out of the marriage, then the court will eventually grant the divorce.
What are the first steps? How is a divorce initiated in Florida?
In Florida, a divorce is initiated by filing what's called a petition for dissolution of marriage. Florida doesn't love the term divorce, so they try to make the terms a little bit more softer by saying it's a dissolution instead of actually saying divorce. So you start the process by filing the petition for dissolution of marriage.
How long does it generally take to finalize a dissolution in Florida, from filing the petition to granting the dissolution?
It really depends on every unique case. Some cases can take the shortest amount of time that it can take in Florida is 20 days from the filing of the petition. Now, a judge doesn't always have a court date set for 20 days out, so sometimes it will take longer than that. But generally speaking, I find that most of my cases last between about 2 to 3 months for an uncontested matter, and they can go as long as 2 years if it's a very contested case.
Is there any waiting period or cooling off period in Florida?
No, there's not.
What are the key factors to choosing the right divorce attorney for your particular circumstances?
You want to make sure that you have a divorce attorney that you feel comfortable with. Divorce is a very emotional process. You also want to have someone that is knowledgeable in the law, of course, but you're going to be dealing with this person a lot. They are going to be handling every aspect of your life, talking to you about custody of your kids, talking about your finances. So ultimately, you want to make sure that you are really comfortable with that person and that you trust their advice, because if you can't trust your attorney's advice, then it's not a good idea to hire that attorney.
When people think about divorce, they often think about going to court. Are there alternatives to going to court in Florida?
Yes, we have a process called collaborative law, where you can actually agree at the very beginning of a case that neither party will initiate litigation. And then, of course, there are other alternatives to collaborative law, like going to mediation before you ever file for divorce, trying to come to a resolution through a third party called a mediator. And then there's also arbitration. Usually people don't use arbitration in divorce. It's usually used in other types of litigation, but it is able to be used. But generally speaking, we think about the collaborative process when we think about doing something different than actual litigation, where you agree ahead of time that neither party will file for the divorce or start the litigation until they have come to an agreement. And if If either party wants to file litigation, they actually have to fire their attorney and get a new attorney and start the process that way. So it kind of really helps people stay in that outside of court process.
Can you say a few words about the pros and cons of each one of these processes that you've described?
It's really just depending on the unique circumstances of the party. I would say that it's always a good idea to talk to an attorney if you're thinking about divorce, because both of these processes are kind of unique to the situation. I would say that most people are going to go down the regular litigated divorce path, but for some people, the collaborative divorce may be the best option. It really just depends on the exact circumstances. So I would say talk to a family law attorney, and they'll give you their opinion as to which one is best for your family.
Let's talk a little bit about children and divorce issues. Can one spouse prevent the other one from seeing the kids during or after divorce? And what would be the legal grounds for doing this, if any?
Well, generally speaking, I would say no, you cannot keep the other spouse from seeing the children, but I do see it happen sometimes. Judges do not like it, and if it does happen and there's not a very, very good reason for it, then the court will come down on the party that has kept the children from the other party very hard. Of course, if there's ever an allegation of abuse or if there's any kind of proof of some kind of emergency situation where the party should be protected from the other parent, that would be a reason to keep the children from the other parent. But in that situation, usually you're going to have the police involved or, the Department of Children and Families, something like that, where another party is going to come in and say that something else, is happening. Generally speaking, though, both parents should have access to the children, and neither parent should keep the children away from the other parent, not only because the court wouldn't like it, but also because it's good for the children to have time with both parents.
Can you describe the most common custody situations that you currently see in Florida?
Well, there's a lot of different situations. Every family is unique. Every situation is different. In Florida, we see a lot of joint custody situations where both parties are sharing custody of the children. We still see some of the weekend parent situations, or we have a lot of military in my area, so we have parents that have very unique schedules and that sometimes they're deployed, and so you have to get kind of creative with the time sharing and do a lot of Skyping and FaceTime. So there's a lot of different issues involved in custody cases, and every family is unique, so your situation is going to be unique also.
Can one parent take the children and move out of Florida during or after divorce, perhaps for work reasons or to be closer to their family?
A parent cannot just unilaterally on their own take the children out of Florida. If they're in the middle of a divorce, they would have to actually file a petition for relocation with the court and ask permission to leave with the children. I have had experiences where the parents have done that, and what we do is an emergency motion for pickup order and ask that the judge order that the children be immediately returned, because the standing order generally says that the children cannot be removed from the jurisdiction of the court while the while you're in the middle of the divorce, and that's because the court has to determine where the children are going to stay. But yes, if you have a job move, or if you need to have the support of your family, you can always request a petition for relocation. You can request that from the court, and the court will hear evidence and determine whether or not that's in the best interest of the children.
Is it possible to get child support while the divorce is still pending?
Yes. Generally speaking, most people are willing to just agree to pay the child support that would be ordered by the court. But if they don't agree, then you can ask for a temporary hearing and set up temporary child support.
How does alimony work in Florida? Is it only for spouses who were legally married?
Yes. You cannot get alimony unless you are legally married in Florida. And alimony is based on a two-part system right now. That's based on the need of the person who's requesting the alimony and the ability to pay of the person who would be paying the alimony. The court looks at a lot of different factors. One of the main factors is the length of the marriage. So as long as you have been married a certain amount of time, and it ranges, from a short-term marriage is considered a marriage under 8 years, a midterm marriage is considered under 18 years, and then over 18, we're talking about a long-term marriage. So all of those factors go into determining both the duration of the alimony, and then the amount of the alimony is based on obviously the amount the person can pay and the other person needs.
Is there such a thing as a lifetime alimony award?
Yes, Florida has permanent alimony for long-term marriages, and then also it can be done in short-term and mid-term marriages if there are certain circumstances. But for a short-term marriage, it would have to be a kind of a crazy circumstance where someone was just, they had some kind of horrific accident or something and they were unable to support themselves anymore. In a mid-term marriage, it doesn't have to be quite as traumatic, but it would still have to be some kind of outside circumstances that would cause that person to be unable to support themselves. But in a long-term marriage, it's presumed, alimony is presumed, but the court is still going to look at those two factors. They're going to look at the need of the person asking for it and the ability to pay of the other person.
Can the amount or duration of spousal support be changed for any reason?
If durational alimony is awarded, then the duration cannot be changed, but the amount can always be changed. What you would do is you would file a petition for modification, a supplemental petition, and that petition would say, the reasons why, you're asking for it to be changed. Generally speaking, it's because somebody has lost income or their circumstances have changed dramatically so that they don't have the ability to pay that amount anymore, or that the other person is making a lot more money and they have, the ability to support themselves. But so if it's permanent alimony, then what you'd be looking at, it wouldn't, the duration of it wouldn't be changed, but the court may order something like $0. So while it wouldn't end the alimony, it would change it to, no amount to be paid. But that leaves the door open so that person, if the circumstances changed again, they could come back and modify again.
My guest today for this Divorce School podcast has been family lawyer Ginger L. Dugan from All Family Law Group in Tampa Bay, Florida. With 10 years of experience, Ginger has the skills and knowledge it takes to handle the most complex of cases, and she's a fierce advocate for her clients. For more information about Ginger and her firm, please visit her website, www.familymarital.law.com.